Friends, hello and welcome to another episode of The Legal Breakdown. I am Jason Sansone with Sansone Howell, Attorneys at Law. We'd like to, like always, thank our host station, KTLV 1220 AM. Every episode of The Legal Breakdown airs Wednesday from 5 to 5:30 p.m. live on KTLV 1220 AM. In addition, the show is simulcast on Facebook Live through the Sansone Howell Law Firm site. And after the fact, you can always watch former episodes on youtube.com. The links for that are on our webpage at sansonehowell.com. We also post it on 3 different places as a podcast if you'd like to listen to the audio only. And you can find that in the major directories of Apple's iTunes. You can find that on Spotify and on the Google Play directory. Friends, as always, we want to remind you, please feel free to call in with your questions. We're going to mention it a couple times throughout the show in case anyone forgets the number. But the number is 405-347-7238. Once again, that's 347-7238. We will take your calls or questions live on the show, or you can post your questions through social media on the Facebook Live video, and we will gladly answer some of those questions. To start out our episode today, just a very quick legal update that we like to touch on from time to time. The United States Supreme Court came down with a ruling today in a very closely watched case. It's Obdusky v. McCarthy and Holthus, LLP. We're just going to call that Obdusky because that's a big mouthful. It's notable for only 2 reasons. One, it was a 9-0 unanimous decision, which might be the first time in the history of the planet that 9 lawyers were able to agree on absolutely anything. Clearly, a 9-0 unanimous opinion for the Supreme Court is rather uncommon. But what the case dealt with was whether the Fair Debt Collection Practices Act, the FDCPA, was applicable in what's called a non-judicial foreclosure. The court found it wasn't. As a matter of consumer rights, for consumer protection, that's a little disappointing. What that means is that if you're in Oklahoma and your house is foreclosed, depending on the circumstances, the lender may not have to go through as many basically checks like the FDCPA as they otherwise might have. And so, of course, that's not going to be today's focus. We're going to do another episode down the road and talk much more in depth about that, but we just provide you a quick little update of 9-0 Supreme Court opinion. Friends, I am joined today by my partner, Kellie Howell. She's the Howell in Sansone Howell. She's a partner here at Sansone Howell Attorneys at Law, and she practices in all areas of family law and criminal defense. Kellie was selected to the 2018 Super Lawyers Rising Stars list and is chair of the Oklahoma County Bar Association's 2019 Law Day. She has a Bachelor's of Arts degree in history from the University of Central Oklahoma, where she graduated cum laude, and a Juris Doctor, which, as we've mentioned before, is a law degree, from Oklahoma City University, where she also graduated cum laude. She's a proud veteran of the United States Armed Forces, where she was a security police officer, which is now Security Forces. She's done tours in places including Bosnia, Saudi Arabia, and Oman. And most importantly, as we love to give warm shout-outs on this show, she is very recently engaged. And so a big congratulations to her and her fiancé, Justin. Kellie, I appreciate you joining me on the show today.
Thank you, Jason.
So we mentioned that Kellie's chief areas are family law and criminal defense. And so today's episode is going to be about the basics of divorce. Now, ultimately on our show, this is going to end up being a multi-part series because there is so much to touch on. That when we talk about divorce, we're going to get into a lot of different facets. There's complications the minute we start to talk about children in custody. We can talk about more noosh or nuanced issues, such as if you're in the armed forces, military divorces, military custody. We're not going to be able to get to all of that today. We're going to start with just the basics. So, Kellie, I come to you, I say, I'm not an attorney. I need a divorce. This is our first consult. We've just sat down. What are you asking? What are you looking for?
Well, I think the first main question we have to consider in any divorce case is whether or not there are minor children. That is any child under the age of 18 or a child who is 18 who is still in high school and has been continuously in high school. That's going to really set the tone as to what type of divorce that you're going to have. because divorce basically has two prongs: property division and then children. If there are not minor children, it is just a property division case. And that's also going to play a factor of, because a lot of people's questions is, how long is it going to take me to get a divorce?
So if I'm hearing you correctly, for our listeners or our viewers live on Facebook, the first consideration, of course, is with or without minor children. And really, the whole scope of the divorce is addressing property and the division of property, and then possibly, if they have children, custody. Is that right?
Yes. Custody, well, the child prong has three sub-prongs. It's custody, visitation, and child support.
But in a nutshell, we're dealing with the marital portion and the child portion.
Yes.
Okay. So I've come to you. You've asked me whether I have children or not. For the ease of this conversation, we're going to say yes so that we can touch on all of our issues. What would be next? Where would we go from there?
Well, I think the first thing that I like to do is basically I sit down with the client and I like to give them a divorce 101. I like to set their expectations and do a little bit of educating of them, such as if you have children in the state of Oklahoma, it is a 90-day waiting period from the date that we file that divorce with the court before the judge will sign off on it. There are some exceptions of getting that waiting period waived. However, short of I'm in the armed forces and I'm about to go to war, you can bet that you're going to have to wait that 90-day waiting period. Without children, the waiting period is just 10 days from the date of filing. So I let them know that first and foremost, so they can know, just at least to start, what's the soonest that this can be finished.
Good. So once we know that timeline, at least to when it's finished, what dictates the remainder of the timeline? Because, of course, as you mentioned, it can be lengthy, it can be complex, it can be different. In most cases, and presumably divorce is going to be very similar, that timeline doesn't really begin till we file, till we start the petition for dissolution of marriage. So what are we working on and communicating with the client before we file to get ready to file, and then after we file? Take us through that.
Well, the first thing that we're doing is we are looking at those considerations, and I let them know that every divorce begins with the filing of a petition. And every divorce is going to end with a divorce decree. And we're going to get that decree one of two ways. We're either going to come to an agreement, or we're going to have a trial and let the judge decide all of these issues. Now, with that being said, less than 1% of cases end up in trial. 99% of the time, we're going to get to an agreement. However, where on that timeline do we come to an agreement? Do we come to that agreement a month after we file that petition, and then we're just waiting out the waiting period? Or do we come to that agreement on the courthouse steps the morning before trial? So that's really going to dictate the timeline. And so I kind of educate them on what to expect in this process. And if you want, I can start with just talking about the property.
That's great. I think our listeners would love to hear that. We mentioned that those are the two different parts. That's the logical first place to start. So let's talk property. What do we need to know?
Well, the first thing we need to know when we're talking about marital property, we are also including marital debt. Property division includes also marital debt. Some of the education that we need to have with our clients is the notion that, for the most part, there are a few exceptions, and we can get into those perhaps in a later podcast, but for the most part, anything that you owned before you were married is classified as separate property, and you get to keep that. But anything that you acquired during the marriage, whether that's wages from a job that you've put in a bank account, 401k earnings, a jet ski, all of the things, and it doesn't matter whose name is on it. Time and time again, well, my car is a Chevy Camaro. I'm the only one on the title. Well, that's marital property. If you purchase that during the marriage, even if your spouse is a stay-at-home mom or dad, it's still marital property, and it's up for what the courts say equitable division.
So if throughout our marriage I worked and I earn toward a retirement, but I'm not even retirement age yet, and then I get a divorce, would I get to keep all of my retirement for myself?
No. Anything on a retirement, whatever you earned during the marriage. So let's just take a hypothetical. Let's say you were married, you were earning towards a retirement for 5 years as a single person. And then you got married, and you were married for 10 years before you filed for divorce. Your wife, upon divorce, would be entitled to roughly 50% of what you earned only during the marriage, from during that 10-year portion.
Right, so that distribution, that half, covers everything. So we've touched a little on property. Now, when we file the case, if I have that Camaro, can I do whatever I want with it?
No, you cannot. Excuse me, I have to cough. One of the things that happens when we file a petition for dissolution of marriage is your spouse will be served with a summons, and something called the automatic temporary injunction takes effect. This is an Oklahoma statute, it's case law, and it basically lays down, it is a court order by the court of what you can and cannot do while this divorce is still pending. One of the main things that you cannot do is you cannot sell any marital property. You can't sell it, you can't dissipate it, you cannot drain a bank account, you can't sell a car, you can't put your home on the market, absent written consent of the other party or a court order.
So, friends and listeners, if you heard that, it's very similar to what we've talked about in a couple of our bankruptcy episodes in the automatic stay. It's obviously not exactly the same, but as we talk about these things and we educate, you can use that in your mind to analogize. We've talked about how when you file a bankruptcy, you get breathing room, you get relief. The goal is to sort things out in the court. It keeps your creditors from, for example, continuing to garnish you. The goal, the objective here is exactly the same, that we want to protect everything the day we file that divorce so that one spouse doesn't go out and party with, blow, sell, hide some of that marital property while the court should be getting to do its job and determine what we're going to divvy up and how we're going to divvy up. That's the whole goal, is to sort of create a pause and protect everybody. So,
well, real quick, Jason, let me jump in because I do think that this is important. Another big thing that the automatic temporary injunction has rules for is involving children.
it's good.
And so I think it's important for our listeners to know that when you file for a divorce, part of the automatic temporary injunction provisions are you cannot hide or secret the children from the other parent. You cannot unenroll a child from a school that they've historically been enrolled in. You also can not take the child out of the state of Oklahoma
Without some other permission.
You cannot do that. And another thing, too, to think about, some divorces are a little bit more amicable than others, but it's very common that people come to see me and they've already done that initial separation. Wife has moved out with the kids to her parents' house. Well, if husband and wife live together in Edmond and wife moves out with the kids to Norman, those children have to stay in Edmond schools, absent leave of the court telling them they can. They have to stay. You also cannot change your insurance or your beneficiary on your insurance.
Are there any exceptions to the automatic temporary injunction? If I need, for whatever reason, to use some of that money or property, can I? What are the exceptions?
The exceptions are that you can, let's say, take out of a 401k or a savings account. The court is pretty strict about it. You can do it for the purposes of hiring an attorney in the case. But the court's going to look at that pretty closely. The court knows, on average, what is reasonable that a divorce attorney is going to charge for a retainer. So you can't take $25,000 out of that 401k and say it was for the purpose of retaining attorney. It's for the purposes of retaining attorney in the normal operation of a business and or for the necessities of life. So if you here's a big one on this. There's a savings account. It's marital property. Mom's been a stay-at-home mom for the last 10 years. She doesn't work. Husband files for divorce and stops giving her any money. She can take money out of that savings account for food and rent and bills. But we just need to be careful that we can account for those things and that we're not being over extravagant.
So let's back up just a little bit. And real quick, I want to pause. Friends, we are halfway through our episode. We're at the 15-minute mark of the 30. We want to remind everyone, we're going over a lot of great information. We're getting to hear about Kellie's practice area. We're talking about the basics of divorce. Feel free to ask your questions online or to call in. You can comment on our Facebook Live, or you can call us at 347-7238. Either one of those are available. So to continue, let's back up for a moment because we talked about the filing the case, the automatic injunction, and that's my fault. We probably jumped ahead. What are the types of documents, what information would a client typically provide to you to get ready to file this? What are the types of things you need to see?
Well, that's the great thing. Part of the provisions of the automatic temporary injunction states that the person must deliver to their lawyer and opposing counsel certain documents. Those are tax returns, pay stubs, any documentation of any account that you have an interest in or claim a marital interest in, and any documentations of debts as well.
Okay. And so that, of course, sort of touches on what you already mentioned, which is there really won't be any hiding anything. That if you tried to game the system beforehand, you thought, well, before I go to a lawyer, let me drain the whole bank account or the 401k. Oh, I've been told by a friend about this automatic temporary injunction thing, so I'm not going to be breaking the rules once we file, but I'll just pull all my money out beforehand. Yeah, you're probably not going to get away with that, are you?
No, you're probably not going to get away with that. I think another thing too, since we're a little over halfway done, that I'd like to mention because it's a big issue in a lot of divorces, is between that filing of that petition and that decree is a very important step that specifically, especially if there are children involved, is what's called a temporary order. Generally, when I file a case, and almost exclusively if children are involved, we do ask for a temporary order. And that'll be a hearing that occurs approximately a month after we file the case. What that temporary order is going to do is the court will either get it by agreement or the court will decide if we argue in front of the judge. It is going to set down additional rules in addition to the automatic temporary injunction that are enforceable court orders until the divorce is finalized or until the court modifies that temporary order. And this is very important, especially when minor children are involved, because it's going to set temporary custody, visitation, and child support. Because when we have two spouses that are separating and not living in the same home anymore, there is a lot often animosity between where are the kids going to spend every night of the week. And mom and or dad need to be protected because, let's face it, going through a divorce is a very emotional time for a lot of people. But the children should not be put in the middle, and we want to safeguard these children as much as possible. So getting a court order where you know that Johnny and Susie are at mom's house these days of the week and dad's house these days of the week. And more importantly, some divorces drag on. So we need to know that mom's going to get the kids for Easter, but then dad's going to get the kids maybe for spring break. You know, we need to get that down.
And it's important to mention to our listeners that, or at least keep in perspective, if you are going through this process, if you ever have to go through this process, whether you're working with counsel, maybe you're not, the word says it all. It's temporary. If at the temporary order you don't get what you want, that it's too much visitation to the other side, not enough support to you, alimony, you're paying your ex-spouse, temporary support order too high, or you're the other side, you feel it's not high enough, it doesn't mean that that's going to be the final outcome. It's not the decree. That could shift. That Yes, we want to make sure it's appropriate in the interim, and we want to make sure everybody's protected. But, neither the court or the attorneys may have even had the time or the knowledge based on how much information could come out to get to that final answer in the case. And so I just want to make sure people remember it, keep in perspective. There's plenty of time to get down the road, temporary orders. Have they ever, in cases you've had, can you give an example of where maybe it's been quite different at the final outcome from the temporary outcome?
Absolutely. A lot of times, the temporary order will be in a situation in Oklahoma. Well, let me back up. Most people that are around my age, and I would even say Jason's a little bit younger than me, but even his age, if you're in your 30s or 40s, most of the time when you were growing up, if you had friends that were divorced, they saw their dads on the weekend. Does that kind of ring true with your?
Sure. Well, and of course we practice together, and so I've heard hundreds of your consultations with clients before, and just like mine can start to sound similar. But I wholeheartedly agree with you that there are generational differences between the way we approach divorce, and I know that's what you're getting at.
And the thing is back when we were growing up, the court used what was called the tender years doctrine, and it was black letter law that children were best off with their mom. And that's not the case anymore. Now the law affords both parents equal time in many instances. But so oftentimes we have a situation in a temporary order where mom has been the primary caregiver with these children and dad has been the breadwinner. And we go into a temporary order, and dad's a good dad, but he hasn't been around quite as much. And so oftentimes at the temporary order, his visitation would be a little bit more than the weekends, but the court will stair step that up and say, you know what, Dad, a perfect example from one of my cases when we were dealing with an infant. Mother was not comfortable with dad having the child half the time. Dad had never changed a diaper. He'd never bathed the child. So we came to an agreement on that order, and it was like, you know what, let's stair step this up a little bit. Let's do a couple of weeks where dad's only seeing a few days a week or for several hours at a time, and let's start out at one overnight at a time. But eventually, by the time the divorce came to a final decree, dad did have the child 50% of the time.
I think that's good for listeners to hear on both sides, because like you mentioned, we may have had a different perspective growing up, and if your only impression of the law was what you saw in your youth, no matter what age you are, it, number one, could easily be a misinterpretation because you were a youth, and number two, things could have changed, that the way we approach the law has evolved over decades. So, we've got about 7 minutes left. I'm going to keep encouraging all of our listeners out there listening either on KTLV 1220 AM or on the TuneIn radio app or through the Facebook Live feed or on our simulcast on our website. Feel free, call in 347-7238 or comment on the social media. Kelly's here. Hey, how often do you get free, top quality legal advice? No questions asked. So let's continue, unless we get some of those great questions. What are some other things that we want the listeners to know in this episode as we build this multi-part series about family law?
I think one of the biggest things, excuse me, is that if you're going into a divorce, you have to recognize that that emotions are going to run high. I see the gamut from very agreeable people that are crying over the loss of love, but still have mutual respect and maturity, knowing that there are children involved, to the other side where people are upset, they're using their children as pawns. And I can tell you that as much as you can mitigate that, that is not the way to do it. Because your children are not responsible for this, but they will feel like they are, and they sense animosity between two parents. So, and that brings me to a point that in Oklahoma, if you have minor children and you wish to get a divorce, The court now requires that each parent attend a co-parenting through divorce class. It is a 4-hour class, and it teaches you some of those things. It doesn't tell you how to be a parent, how to change a diaper, how to talk to your kids about the birds and the bees. It teaches you how to minimize the impact of this divorce on your child and what to look out for. We should never use a child to relay messages between mom and dad. They are children, they're innocent, should be protected, and they shouldn't be dealing with such an adult concept.
That's great. Is there any exceptions to having to take that class?
No, there are no exceptions. The only partial exception to that is most counties in Oklahoma require that that be done in person. There are many providers throughout the state that do this. However, if there is military service, or I did have one instance where we had a basically homebound individual with a disability, with judicial permission, sometimes they are allowed to take that class online. But you must take that class. And if you don't take that class, the majority of the judges, I've seen it before when one parent just says, I'm not going to take it. And the judge will sign that divorce decree, and he or she will put in that divorce decree that they get no visitation with the children until that certificate of completion is on file.
It's, understandable and fair, but that's a very harsh consequence, obviously. So the message for our listeners is don't make up excuses. Take the class. How long does the class take? What are we looking at?
It's a 4-hour class, and the cost associated with it, depending on which provider you choose, is around $40 to $50.
Are there any options? Do anyone allow that fee to be waived? Does Legal Services offer a free course? Can you demonstrate a certain income and get that reduced?
I do not know of any options. The cheapest one is $40, and I have not seen any waiver of that price at this point. There are some waivers for filing fees for the actual divorce, but I haven't seen anything on the cost associated with the class.
And so what would those be for the filing fees then?
Well, generally it's a little outside my wheelhouse, because generally if you can afford an attorney, they're not going to waive your filing fee. But it is much like a criminal defendant. It involves going down to the court and filling out a pauper's affidavit, and that being reviewed by the court clerk and them either denying or granting that.
Right. So, what that is, and we've touched on this a little bit when we've talked about bankruptcy as well. If you can afford counsel, it's almost always assumed that you should therefore be able to pay the fees to the court. Like in a Chapter 7 bankruptcy, it's $335 to file the case. Chapter 13, $310. You can't say that I won't pay the court the $335 necessary to keep the lights on and have a courthouse, but I want to pay $1,000 to my attorney. However, if you don't have counsel, if you are a pro se defendant or litigant, and then you may be able to get that reduced or waived. With the bankruptcy court, right, there's a form and application you have to do for Oklahoma County or any other state court county. It sounds like it's pretty similar.
And the counties vary on their filing fees, but generally for a petition for dissolution of marriage and to have a summons issued, it waivers around $250 on most of the counties in Oklahoma. Some of them are $260, $214. Sure. Some of them are a little less or a little more.
But only one side's going to have to pay that to initiate, the petitioner. And, depending on how amicable we are, maybe we just want to split up. We're going to do this on our own. We're going to have what we call a waiver divorce, which we'll touch on in later episodes. You can split that cost. Friends, we are out of time. I thank Kellie so much for being on today's episode. Real quick, Kellie, tell us what we can expect in future episodes. Where are we going to go from here with this multi-part series?
Well, future episodes, we're going to basically take a deeper dive into custody. We're also going to touch on military divorce. As a veteran, I like to say that I take a lot of pride in representing my military and veteran members, and there are some additional considerations on property division and custody with military families.
That's great. We look forward to the military divorce. We think that's going to be highly interesting to our listeners, especially here in the Mid-Del area. Friends, this has been the Legal Breakdown. Have yourself a wonderful Wednesday evening.